Pardon me, I had to get a break because I got some disturbed in the process, but to ensure that I don't have to start afresh, and I'll try and continue. So, in fact, what I'm basically saying is that when you look at the Helen Suzman Foundation and the assertion made by the Department of Home Affairs, that one they've been launching these cases, you can only say that this is desperation, and the department is acting, as if they are operating at the same level with the Helen Suzman Foundation, not realizing that they are a government department and they've been beaten at their game, by these applicants, the Helen Suzman Foundation and COMSA, to the extent that they're even advising the clients, of the Helen Suzman Foundation, giving them legal advice. I mean, that is that is unheard of. The Zimbabwe exemption permit holders are represented, in this particular case. And the fact that the Department of Home Affairs puts itself in a position to try and advise them or to give them, legal advice and say that these are false promises, it's misguided and misdirected. It's very unfortunate. And this is acting, I think, in an amateuristic manner. And this shows, serious desperation. The Helen Suzman Foundation is not, no COMSA. They have not made any promises in this particular regard. And the fact that now these guys continue to say, they must make this application can only show that, indeed, the department is very, 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 defeated and feels like, they must try to resort to underhand tactics. This is an underhand tactic. Now, this order in no way, has been dismissed. In fact, if anything, this order is actually a victory for the applicants, because what it basically specifies, is to dispel, the notion that had been put forth, by, the Department of Home Affairs, and that, it cannot, these orders cannot be enforced. The Department of Home Affairs is supposed to start afresh, over the whole process and make sure that a fair process is followed. That is the order as it stands. If they want to appeal, they can go and appeal that, whatever the case, but that does not take away, the rights of the ZDP holders. So the ZDP holders need not to listen, to this, hogwash that has been put here, because that's exactly what it is. It is hogwash. Unfortunately, it is. Now, and we must also remember that the minister got a 10%, personal cost order in the Constitutional Court, and I think the Director General is at 15 or 25% in the Lawyers for Human Rights case. So this is actually to try and appease those that would be very hurt, by that position, because the minister showed that he has no regard for the law in that 2017, judgment and the excuse that he brought by. So this statement is actually being, brought out to try and soothe the minister and caress his feelings in this particular regard. In addressing this matter in this particular format. So this is very unfortunate, and it's not addressing this case per se, but it is actually addressing that particular case to try and make themselves feel better, and that maybe they can have, show the taxpayers that, money is not being wasted on, when these costs are being paid. Now, furthermore, that there are calamities and all those issues, honestly, that is in the first place. That is why there was an order, because it was the June order shows that the minister has conduct, it violated rights, and those are calamities. So we cannot detract from that. Now, so in this particular regard, the minister is just using this particular, platform to try, and feel a lot better, with himself, especially with all these losses that he's been suffering, in court. He has, he can still appeal and go further up until it goes to the Constitutional Court. Let's hope that he is better, guided as to what he needs to do, because he cannot be given legal advice because he's legally represented. But in fact, the minister is wasting time. Now it's only 6 months, before the time that he was given in order for him to act and start the process de novo. And which means that if, he does not, and it's June 2024, he's going to found to have been again not complied with the court order, and might find himself again, in a similar position with the 2017 judgment, if he has not taken appropriate steps, when he knows that he is supposed to, at least take steps, before, because he has not succeeded. If not, he's only going to be dragging time, and the adverse effect is that, of course, the ZDP holders are going to be affected by the uncertainty as to where their lives are going. But If anything, this has not been a success at all for the Minister of Home Affairs. What has been said is mere propaganda, and the propaganda is very weak, because anyone who reads that judgment will see that even the minister had there are costs against the department, that were issued in that particular order, for the supplementary affidavits that they had, to file. And there were no cost order, in the main application, concerning that these are the applicants. That can only show you that there was merit, because these applications were necessitated by the behavior of the minister and their lawyers in rejecting the requests that were put forth by the applicants. So, be rest assured, the Helen Suzman Foundation and COMSA are in the right direction in this particular case, and their legal position is sound, and it was necessitated by the actions, of the respondents. So the respondents are the ones that should be licking their wounds. Thank you.